Well, the federal government has signalled it may try to speed up a High Court hearing on its refugee swap deal with Malaysia. The court says a full bench hearing won't take place for another 2 weeks, and that puts the government's refugee deal on hold. Immigration Minister Chris Bowen is in our Parliament House studio. Minister, good morning.
Good morning to you, Fran.
Can you speed up this High Court hearing, or do you have to wait a couple of weeks?
We're certainly exploring doing that, and it'll be up to the court at the end of the day. But we believe we're on very strong ground, very solid ground in this case, and we do believe it would be better that it would be heard as soon as possible. So the Solicitor General will make that case to the High Court, but it's a matter for the High Court as to how they respond to that.
This is a real mess for the government, isn't it? Far from delivering certainty and closing the door to people smugglers, which you say is the mission here, the signal now, at least for the next fortnight, is anyone who comes here won't be sent to Malaysia, they'll stay right here.
Well, I've been very clear in my comments, Fran, deliberately that people smugglers and asylum seekers should be clear that this is an interim injunction. It's not a result of a court case, and that anybody contemplating coming to Australia on the basis of this injunction should not. It is clear, of course, and one of our arguments to the court is that people smugglers will spin this and lie about this and say that this is some sort of green light. It's not, but nevertheless, we will be making the case that it would be better that there's more certainty. These are always difficult issues and controversial issues, Fran. I said on May 7 when we announced this that we could expect protest, resistance and legal challenge. I don't think I've been proven wrong. But what is important is how you respond to it. Of course, there is a pattern to this. I mean, the previous government's Nauru option was declared invalid by the federal court at one stage. That's not happened to us on this. It's simply an injunction. But unlike the previous government where Nauru was declared invalid and then that was overturned on appeal, my point is that these are always complex and controversial matters.
This is not the federal court. This is the High Court. Why are you confident that your plan is safe from a successful High Court challenge?
Well, of course, Fran, we didn't do this lightly, and we didn't do it based on a view that this wasn't legal. We had legal advice all the way through that this was legal. The Act is clear. The Act is clear that a third country can be declared and that the Minister can declare that third country, and we've followed the Act to the letter.
A third country can be decreed, but a third country that is not a signatory to the Convention, a third country with an appalling human rights record? Is the Act clear on that?
Well, with respect, Fran, Malaysia is a country which has given commitments to Australia in terms of the arrangement we have with them. It's also a country, by the way, which has agreed to the fundamental tenet of the Refugee Convention as part of this arrangement, non-refoulement, which is a big step forward. And Malaysia has, for some time, given asylum seekers the capacity to have their claims heard through the UNHCR. And so, look, we've made this declaration based on strong ground, strong advice, and we would argue it vigorously before the court, and we think it's better it would occur sooner rather than later.
Minister, Malaysia has given commitments to Australia, but these are not legally binding commitments, and it is the case, isn't it, that the Australian government cannot guarantee human rights in any foreign country where it has no jurisdiction, not much less in Malaysia, which, as I say again, is not a signatory to the Convention.
Well, Fran, the majority of the world's asylum seekers are in countries that aren't refugee signatories, refugee convention signatories. We've worked.
Is that
with
any
Malaysia.
reason for us to send more there?
No, we're taking 4,000 out. Let's not forget, Fran, and we're taking 4,000 people and giving them a chance of a better life in Australia. The first of which arrived this week, and they are people who didn't have standing in yesterday's court case. People who didn't have standing in yesterday's court case are the people who've been waiting for resettlement in Malaysia, who don't have the money to afford a people smuggler. The people who didn't have standing in yesterday's court case are the people who die on the boats on the way to Australia because they think that gives them a better chance of resettlement. There are people without a voice in this argument. These are the people who don't have the resources to get to a people smuggler. These are the people who feel they have to risk their lives and some die on the way. I make no apologies for a tough line, and I make no apologies for arguing the case vigorously that these people should have the right to have a say in this as well.
But the people who are launching this case against you are people who have risked their lives to get here. You say this is about stopping the people smugglers, but it's also about denying people who are fleeing persecution, fleeing violence, seeking a safe haven in Australia, coming here and asking protection. That's who you're stopping.
Well, we're stopping people getting on a boat to do so, Fran. And what we're doing is we're saying that we want to take more refugees. I make no apologies for saying we want to take more refugees. I also make no apologies for saying that we should not have the situation, it is not morally acceptable to me, to say to people, if you risk your life on a boat to Australia, that will give you a better chance for resettlement. We should be saying, and we are saying, if you go through the UNHCR and you get mandated as a refugee, you'll have a better chance of resettlement in Australia, and we will not encourage people to take the risky journey. Now, people who go out there and say, this is morally unacceptable, well, my question to them is this: is it morally acceptable to force people onto a dangerous boat to have a chance of resettlement? And if it isn't, what are you going to do to discourage it? The government's position is clear.
In policy terms, if the highest court strikes down the Malaysia swap altogether, though, it's a free-for-all. People smugglers know the Australian government powerless to stop them bringing people to Christmas Island. It's a debacle.
Well, we're not working on that basis, Fran. We work on the basis that we are on strong legal grounds. We have very strong legal advice, and we'll be arguing it vigorously.
What about your legal grounds in terms of the challenge to your role and responsibilities as the legal guardian of unaccompanied children seeking asylum here? What choice do you have as the legal guardian, in good conscience, to, surely it's very difficult for you to argue that it's within your responsibilities to send children to another country like Malaysia, where they will be at greater risk than they are here?
Well, Fran, the Minister for Immigration has many responsibilities. Of course I do. And the Act is very clear about those responsibilities. And the responsibility is to administer the Act and ensure the integrity of our immigration system. And of course...
And to act as a legal guardian for unaccompanied children.
And of course, Fran, I have special responsibilities to unaccompanied minors. Of course I do. That's why we've negotiated with Malaysia the protections that we have. Now, Fran, these are difficult issues. Of course they are. Now, if you had the position that an unaccompanied minor could never be taken from Australia, that would be an untenable position. I'll give you one example. One example is, Fran, we have an agreement with Afghanistan, signed between Australia and Afghanistan and the UNHCR, to return people who've failed as asylum seekers. Now, that has special protections in it for unaccompanied minors. But you can't have the situation where you say, look, if you're an unaccompanied minor, and even if you're not a refugee and you make a case, you can't make a case that you're a refugee, then therefore you have an automatic right of stay in Australia, because that would not be a sustainable outcome. What's important is that we have all the appropriate care and protection in place as we deal with the complex issues of unaccompanied minors. My responsibilities of guardian are very important. I'm the minister who's taken kids out of detention, for example. I take those responsibilities seriously. But I also take my responsibilities seriously to the 18,000 children in Malaysia waiting for resettlement, the 1,200 unaccompanied minors in the streets of Kuala Lumpur waiting for resettlement. And I take my responsibilities seriously to try and stop children being on boats, because I never want to take another call like I did on the 16th of December last year, telling me that children, including a 2-month-old baby, had drowned off Christmas Island.
Minister, but if you take these responsibilities seriously, and you've given all signs ever since you've taken up this portfolio that you do, you've criticised the Nauru option in the past for leaving children in limbo for up to 5 years. How do you reconcile then the fact that children, unaccompanied minors you send to Malaysia, could be there for much longer than that? And how can you just explain to everyone listening how you can ensure that these children are protected, their welfare is protected in Malaysia?
Well, because we've been working with the UNHCR and the IOM on the appropriate arrangements. And of course...
But what are those arrangements? Can you explain to us how you are going to keep tabs on all the unaccompanied minors sent under this Malaysian solution to Malaysia?
Well, Fran, again, let me go back to basics and I'll answer your question. What we've said is no blanket exemptions and a case-by-case approach on the vulnerabilities of any particular minor. That goes to the decision as to whether to transfer and the care and support that would be in place after transfer. And that goes to them being in the transit centre and for an assessment of their needs, for appropriate care and support to be put in place in conjunction with the IOM, in conjunction with various non-government organisations in Malaysia, etc. And of course, we would make sure that was in place for any individual concerned. I hope we don't have to send any children to Malaysia, because I hope the boats stop coming, and I hope that people don't make that dangerous decision to put their kids on boats.
Well, there's 16 there now in the first boat.
Yeah, and
will you be sending them?
Well, we've said no blanket exemptions, and people can work on the basis that they'll be sent to Malaysia. Now, we also have the situation of people sometimes claiming to be minors. We've had one person who claimed to be a minor on that boat. It's now been established clearly that he's not a minor. That happens not irregularly in this area. That underlines the unworkability of the blanket exemptions. That, frankly, would be a naive and unworkable approach.
Okay, but if the word comes after this is in place and an unaccompanied minor is sent to Malaysia that they have not been cared for, that they have been abused, suffered violence or abuse of some form, that's on your head.
Well, Fran, I'm the minister. I take responsibility for what happens in my portfolio, and I take responsibility for breaking the people smugglers' business model. That means making tough and unpopular decisions from time to time. But that's the role that I've taken, and that's my job, and I will do it.
Chris Bowen, thank you very much for joining us.
Thank you, Fran.
Chris Bowen is the Federal Immigration Minister. It's 14 minutes to 8 on Breakfast.